Hello everyone and welcome to the first of our video tutorials on involuntary manslaughter. Today we're going to be looking at unlawful act manslaughter. I'd like to start by reminding you of the different homicide offences so that you can see where unlawful act manslaughter fits into the big picture. Our homicide offences then, we've got murder, which is the unlawful killing of a reasonable person in being under the Queen's peace with malice aforethought express or implied. We've studied that. We've also studied voluntary manslaughter, which is where you've got the actus reus of murder, so someone's been unlawfully killed. You've also got the mens rea for murder. However, there is a partial defence of diminished responsibility or loss of control, which reduces what would have been murder to voluntary manslaughter. Today, though, we're moving on to involuntary manslaughter, which is very different from voluntary manslaughter. Involuntary manslaughter, we've still got the actus reus of murder, someone has been unlawfully killed, but for this homicide offence, they lack the required mens rea of malice aforethought, that is, they didn't have intention to kill or they didn't have intention to commit really serious harm. And there are many situations that can give rise to this outcome, and therefore there are two different types of involuntary manslaughter. We've got unlawful act manslaughter, which I've shortened to UAM, and we've also got gross negligence manslaughter, which I've shortened to GNM. But today we're going to be looking at UAM, unlawful act manslaughter. Lawful act manslaughter is where the defendant has set out to commit a lesser criminal offence, but in doing this lesser criminal offence, they have actually caused the death of another person. So to give you a classic example, if I'm texting when driving and I run into somebody and kill them, that can be unlawful act manslaughter. Because I've done an unlawful act, texting when driving, I didn't mean to kill somebody, but I have killed them. Now, in order to find me guilty of UAM in that situation, there are four elements that need to be proven. Firstly, the defendant must do an unlawful act. Secondly, the act must be dangerous on an objective level. Thirdly, the act must cause the death. And fourthly, the defendant must have the mens rea for the original unlawful act. Just to refer back to that example I've just given you, if I'm texting when driving, that is an unlawful act. It's a crime to be texting while you're driving. The act of texting while driving is dangerous because a normal person would say it's a dangerous thing to do. In the situation where I've run into someone and killed them because I was texting, I've caused their death. There's no break in the chain of causation. And I've got the mens rea for texting, which was the original unlawful act. So unlawful act manslaughter is also sometimes called constructive manslaughter. And that's because what we're doing here is we're adding these elements together to find the person guilty of UAM. What I want to just bring your attention to here quickly before we look at the elements of UAM is I want you to appreciate that UAM sometimes overlaps with murder. And what I mean by that is often something that could be murder could also be classed as UAM. And it really depends what the CPS, what the prosecution want to charge the defendant with. Come back to the texting example that I gave you a minute ago. If I'm texting when driving, that's an unlawful act. It's dangerous. I've run someone over and killed them, causing their death, and I had the mens rea to text. So that can be UAM. But when you think about it, that could also potentially be murder. Because in that situation, I've killed a reasonable person in being under the Queen's peace. And you could say that I've got a bleak intention to kill. Because if you're texting when driving, death or serious injury is virtually certain, and the defendant must realise that. So it is possible that someone could be guilty of murder or unlawful act manslaughter. Another example I could give you here is we looked at the example when we were doing murder of if I punch somebody in the face and they fall and hit their head on the curb and die, that can be murder because I've unlawfully killed somebody and I've got intention to cause GBH, which is enough for murder. But that could also be UAM because punching someone in the face is an unlawful act. It is dangerous. It has caused their death, and I had the mens rea to punch them in the face. So it makes life a bit tricky for us lawyers because one incident, one offence could be classed as either homicide offence. So in the exam, if you've got a scenario like that and it just tells you to advise, it doesn't say on murder or manslaughter, then you've got to talk about both possibilities. It could be murder, do that first because that's the most serious offence, but it could also potentially be UAM and explain that. So just to come back to remind you then, these are the 4 elements that we're looking at today. And as usual, we're going to look at each in turn, starting with there must be an unlawful act. To find our defendant guilty of unlawful act manslaughter, firstly, there must be an unlawful act. And the clue is in the name, unlawful act. So the death must be caused by an act which is a criminal offence. An omission is not enough for UAM. And this is illustrated by the case of Lowe, where the defendant was originally convicted of UAM when he starved his son. But that was quashed by the Court of Appeal and said omissions are not enough for UAM. Okay, so we've got to have an action. So the act might be texting when driving, a punch in the face, etc. But it's got to be an act, not an omission. Second case that we've got here that shows that we've got to have a criminal act for unlawful act manslaughter is the case of Lamb. And here it's a bit of a sad case. We've got 2 boys who were playing with a revolver and they didn't understand how revolvers worked. So there were 2 bullets in the chamber of the gun, but neither was opposite the barrel. So the boys wrongly believed that this meant that the gun wouldn't fire if they pulled the trigger. One of the boys pointed the gun at the other and fired. And as he pulled the trigger, of course, the chamber turned once and the gun went off, killing the boy. And the other boy was charged with unlawful act manslaughter. Here, he was not guilty of unlawful act manslaughter because there was no unlawful act. Because the boys misunderstood how the gun worked and they were just playing a game in their mind, there was no assault. The boy wasn't scared that he was going to be shot. So because there was no assault, there was no unlawful act. So in other words, you've got to have a completed criminal offence before it can be unlawful act manslaughter. The second requirement for proving UAM is that the act was dangerous. Now, a key case to look at here is Larkin. I remember this case because I think he was larking about with a cutthroat razor. And what happened here was Larkin found out that his girlfriend was cheating on him. And he was threatening the girlfriend and her new partner with a cutthroat razor. And he said that he wasn't intending to touch them with the razor. He was just shouting at them, assaulting them with it. Now, the girlfriend, this is where it all gets a bit strange, apparently blundered onto the cutthroat razor and her throat was slashed and she died. Now, he was charged with unlawful act manslaughter and his argument was, well, he shouldn't meet requirement 2 because he didn't think threatening them with the razor was dangerous because he never intended to lash out with it. He was just trying to scare them. But the court rejected that and they said that the defendant doesn't have to think the act is dangerous. It's what the reasonable man would say. And the reasonable man would say that if you are threatening people with a very sharp razor, there's a risk of some harm. So it meets requirement 2. In the case of Church, this was added to, and the court said that the test for whether the act is dangerous is whether a sober and reasonable person would foresee the risk of their act. We then had R and JM and SM, And this was a burglary that went wrong, and one of the defendants actually ended up running over the victim and killing him. Obviously, he didn't mean to run over this guy, he was just trying to escape. He was convicted of UAM, and again, he was trying to argue, well, I don't think it was dangerous because I just planned to go and steal his stuff. I wasn't planning on hurting the man. But the court said it doesn't matter what form the harm takes, as long as some harm is foreseeable. So in other words, although it was slightly odd that he ran him over, you can foresee from a burglary someone might walk in and there might be some harm. So in order for it to be dangerous, we're just looking at objectively, would the jury think that some harm is likely to result from the act? On this same issue of dangerous act, we've got the case of Mitchell. We studied this case when we were doing transferred malice, if you remember. And this was an argument in a post office queue where a man punched and pushed a man, and the man staggered backwards and fell into an elderly lady who tipped over and later died. Now, our defendant was convicted of UAM because when you think about what he's done there, he's done an unlawful act, a punch. Punching someone is dangerous. It has caused death of a lady, and he had the mens rea for the original unlawful act, i.e. the punch. And the court said that the unlawful act doesn't need to be aimed at the victim themselves. So his argument is, well, I know it's dangerous on the man I punched, but I wasn't intending anything to happen to a little old lady. Okay, but that was irrelevant because the unlawful act doesn't have to be aimed at the victim. We can transfer your mens rea to hit this bloke to whoever happens to fall over. And we know that from transferred malice. Goodfellow, it was held that the unlawful and dangerous act can be aimed at property. It doesn't have to be aimed at a person as long as you can foresee some harm. So here our defendant set fire to his council flat so that he could be rehomed, but unfortunately he killed his wife and son and another woman in the fire. So his argument is, well, I wasn't aiming an act, I wasn't punching a person, I was aiming it at a building. But that doesn't matter, it's still dangerous. And you can see from the facts here, the facts are very similar to Nedrick. And that's what I was saying before, that a lot of the time, something that could be murder, so it could be murder, Nedrick, using oblique intent. It could also be UAM, like it was in Goodfellow here. Our third requirement for UAM is that it must cause death. So we use our usual rules of causation here. John Stone tells us that it must be proven that the unlawful act did in fact cause the death. And in this case, it couldn't be proven that the dangerous act, which wasn't very nice on the victim, it couldn't be proven that this actually caused the heart attack. Causation in UAM has been problematic in terms of drugs cases. In Cato, it was said that if the defendant injects the victim and they die, he can be guilty of UAM because he's done the unlawful dangerous act of administering a noxious substance. If, however, the victim self-injects, so the defendant gives them the drugs, maybe they've prepared it as well, but the victim self-injects, that will be a novus actus interveniens. So the victim will have broken the chain by their own daft action of self-injection, and that comes from the case of Kennedy. So if they've self-injected, you can't prove causation for UAM. Another drugs case here was Evans, and this was where the defendant supplied her 16-year-old half-sister with heroin. Carly self-injected, so that broke the chain, it couldn't be UAM. But the big sister failed to call an ambulance and Carly later died. And our defendant was guilty of GNM, gross negligence manslaughter, which we'll look at in the next video. So if the defendant supplies the victim with drugs and the victim self-injects, that breaks the chain, it can't be UAM. But if they don't call an ambulance, it'll make it gross negligence manslaughter. The final requirement for UAM is that you have to have the mens rea for the unlawful act. They don't have to have the mens rea for death, obviously, because then it would be murder. So here in Newbury and Jones, we only had to show that they intended to push the concrete off the bridge.